actually sat down with an attorney, and we've and I think one of the questions that I did get is I think it was how much should one have in assets before considering an estate plan? And I think it's pretty much anything under $100,000. You need to at least have your power of attorneys in order and your will created, and anything over that you need to start considering the trust, right?
Yeah, I would say anyone actually over the age of 18 needs to consider it, because you do need those powers of attorney. As soon as your children become an adult, the parents don't have a right to their medical records anymore. They don't have a right necessarily to make those medical decisions. So if you do have a child who turns 18 and is going off to college, I would say, get them their powers of attorney in order so that, if something does happen, you can help them out. But yeah, everyone does need to have powers of attorneys over the age of 18. And then especially if you have minor children, or even if your estate is small, I would still recommend doing a will, so that at least, the state is giving you the right to say what happens to your stuff if you're not able to, or if you pass away. So why would you give up that right and hand it over to a court? Even if you have an estate under $100,000, there's still paperwork that needs to be filed, and affidavits of your small estate affidavits, and there's still, a lot of things to do. And then who decides, there is that, the state laws as to who would inherit, but maybe that's not exactly what you want. So you would be giving up your right to say what happens. And, of course, we would want to be able to have things done the way we would want them.
Okay. Sounds good. So once you've completed your estate plan, how often should you look at it or update it or sit down with your attorney to go over it? Or is it just a one-time thing?
Well, no, it is a living, breathing document. It can change over time, and especially if you have any changes in your life. So say if you get divorced, if you get married, when I do estate plans, I always include any future born children, but if you want to name them specifically in there, if you have, more children or, grandchildren, if you start becoming a grandparent and you want to make sure that they will inherit directly, not just through what you give your children, but you want to name them as well, then those are things that you can go back. You don't have to redo the entire document. We can just do an amendment and add those things in and make the changes. Also, if you move out of state, then you always have to change your documents when you move to another state, unfortunately, because each state's laws are different. So if you move out of state, if you get divorced, if you get remarried, if you have more children or grandchildren that you want to specifically include, or if you win the lottery or something wonderful like that, then you may need to look at estate taxes. So we want to, make sure we modify that. But generally every 5 years, if none of those things happen, every 5 years is a good time to look at it just to see if things have changed, or if you have any of those life changes that you want to make sure are covered.
Oh, okay. So whenever we have a life-changing event, or at least every 5 years. And you did mention something about living out of state, and that was a question that we have, because we do have people that will be listening to this call that will not be in the state of Illinois. But so as you mentioned, if we're in Illinois now and we get a estate plan and we relocate to another state, then we would actually need to sit down with another estate planning attorney licensed in that area to go over and make sure that the estate plan is following the rules within that state. Correct?
Yes, you would. Yes, and it would probably have to be redone. It should be simpler for the attorney to do, though, because you already have everything in place and who everyone is. So you're going to name as executor trustee and who the beneficiaries are. So a lot of the pre-done work is there, but they have to make sure that there are documents that are in compliance with that state's laws. Okay.
Now, for people, because we know as we get older, some people may have vacation homes or homes like that in other states. Which state would take precedence when you have property, or if you're traveling back and forth? What takes precedence? Where would that estate plan need to have a foundation? What would its foundation be if you're a traveler or you property in other states.
Right. And yeah, that comes up a lot, especially, the typical situation is you get older and you have a, vacation home somewhere down south. And it's going to be the state where you consider your residence, or what it counts as your residence. In Illinois, that's basically, if you're here most of the year, it also counts where you vote, where you have your driver's license, where you're possibly filing income taxes. So if that is Illinois, then you would still have an Illinois one. If you spend like 3 or 4 months out of the year out of state, Illinois would still be your home state.
Okay. That's good to know. And now, a big question, because we're talking to you. You are an estate planning attorney. I totally recommend for moms, after they complete the program and they have got their thoughts together and know kind of what they want to do, to sit down and speak to a licensed estate planning attorney. But we know that there are online programs or things that you can order on TV that says you can create your estate plan or you can create your will or what have you. What is the difference? And I know this may seem a little biased because you are an attorney, but what is the difference between actually sitting and talking with someone and doing your estate plan and trying to do it with documents that are online or, that you purchase from someplace?
There is actually a big difference between the ones that I have seen online. I have looked at 2 of the major providers of those, and I've gotten a hold of their documents and reviewed them. And they are unfortunately not up to par with what is needed. Oftentimes, even though they say, like it's an Illinois will or an Illinois estate plan, they don't include the things that Illinois requires for those documents. So there's a lot of tax provisions that are missing, a lot of common things that should be included that are missing out of those. And unfortunately, it can create unintended consequences because, again, you're out there and they should be providing you with good documents that you don't have to worry about, but they're not. And unfortunately, only attorneys can advise you on that. So you can talk to them, but they're just salespeople. They can't give you legal advice on it. So if anyone here has any questions on a particular provider, I have a list. I have gone through a couple of documents from those providers, of what's missing from those documents. But you may think you don't need any of those clauses because you have maybe a smaller estate. But the problem is that you're not going to know that if anything is missing or wrong. Your family is the one who's going to be left behind in finding out the mistakes or the big gaping holes that are in these documents because they just weren't done right. Another problem I've seen is when I have reviewed some people who have had these estate plans that they've bought online, and they do them themselves, is they just don't understand what is being asked of them when they're filling out those forms. There's mistakes, and they seem simple, but it's very confusing to my clients because they think they understand what they're being asked and what they're answering. But when I see the documents and I say, no, it means this, they say, oh, that's just not what I thought they were asking. So then there's a lot of mistakes being made. Another big issue that I've seen with these types of documents is that, you got the document, they deliver it to you, you still have to go through a signing ceremony and get them, executed properly. But all the ones that I've seen are not done properly. Illinois has very specific rules, and most states do, about how these documents are signed. Which ones get notarized, which ones have witnesses, how many witnesses are required, who can be a witness and a notary, and most importantly, what order should all the documents be signed in, because there are specifically, like if you have a trust and a will, the trust has to be signed before you go and sign the will. So these are things that people just would not know. Even who is in the room with you when you're signing. If you have family members in the room, later on, if there's an issue, then that could be basically get rid of your entire document. So when I do a signing ceremony, I have a checklist. I note each detail as to how it's signed, what order it's signed, who's in the room. I can even be called as a witness later on to prove in court that it was done correctly, whereas if you do it yourself, there's no one there to prove that. So unfortunately, documents online, I would definitely go online, read up on estate planning. You can review the documents just to get a feel for what is included in some of them, but I would definitely not use them.
Great. And you actually brought up a very good point that I touch on in our program. As I mentioned before, our first step in Mom's Master Plan is communication. And I talk about why it's so important and how it fits. And the reality is that we need to communicate our wishes to our family, and I don't mean to everybody, but at least to the key players involved. And when you said when you mentioned the signing ceremony and the people that are in the room and who could be called as a witness, what about someone contesting it because maybe Mom didn't communicate it to everyone, or she just kind of wrote it down and did it, and maybe someone is thinking, oh, she wasn't in her right mind when she did this. When we're talking about this signing ceremony and creating a trust and wills, at what point or who can contest it? How legal is it for somebody to contest it? How far would they get? Let's talk about if somebody wants to contest a will or a trust, if it hasn't been communicated. How does that work? And I guess I'm pretty sure if you don't have the proper documents and it's not in proper order, anybody could really contest it. So we're not even going to talk about that. But if we have everything in order and it was done correctly, what right do people have to contest a document, a will, or an estate plan?
Well, that's a really good question. That's one of the things that I do address when I am, consulting with clients on this. And it depends who it is, and is it someone you're leaving out of the will completely, or is it someone that you're including but you think that they're not going to be happy with what they're receiving? So there's different ways that you can address it depending on what the situation is. For instance, I always include a no contest clause. So basically that says especially if this is someone who's included in the will, but you're afraid that they may go and fight the will or the trust. But basically you're saying, I give, John Doe X amount of money, and then later on there's a clause in there that says basically if they contest this, they're giving up their right to any gifts, and I rescind any of those gifts. So it's discouraging them. There's no way to completely stop it from happening, but you can certainly discourage it. So if John Doe is getting, $20,000, but he thinks he deserves more, and he contests it, he's giving up the $20,000 that you're giving him. So what happens is, he has to weigh the risks. If I go to court, I could win, but I could also get nothing and wind up with zero rather than the money that I am being given. So oftentimes that's one way that you can discourage it. If you're talking about someone who's older in life and maybe has they may bring up mental capacity issue. You can always go to the doctor and get that medical clearance, have their medical capacity tested. I do that with older clients who maybe have a question on, especially if you're 75 and older. I would definitely, get that medical clearance from the doctor, and then there's no question about it. They can't even use that as an argument later on because they were tested just before they had it signed. And then also, like me, when I talk to clients, I make notes and I'm feverishly taking notes while I'm talking to you. But one of the things I'm noting is your appearance, whether you're able to hold on a conversation, are you well-groomed, things like that. So that it kind of gives you a notice to what is your mental capacity. Whereas if you're disheveled and you don't know what day it is and, you don't understand your finances, then obviously we have some issues there. So those are some things that I could always be called on as a witness later on if it ever does get to court. But yes, those are things that we can address. You can't completely stop it, but you can, of course, discourage someone contesting that.
Which, again, speaks to why it's so important to have an actual attorney do this as opposed to trying to do it online, because that attorney may at some point, if necessary, have to speak on your behalf and your mental capacity. Like you said, you're taking notes. You want to make sure that this person is making the right decision and they're making it of their own will and accord. And so I guess that's another good point as to why you would want to have an actual attorney to do this for you. So in case something like this happens and somebody may want to contest it later on, you can at least say, and you won't be a biased party. You're not speaking on anyone's behalf but that person. So they can't say, oh, you're the favorite daughter. No.
Right, and that goes to some of the unintended consequences of if you do it online and, you know, maybe there was a mistake and you honestly didn't know that that's what you were saying when you filled it out. So whereas if you go through me, then or any attorney, then they know what you want and that's what you wanted.
Right.
Yeah, that is another benefit.